Hello, my name is Medania Rodbalio, and my presentation today is for global law, and I'll be focusing on week 6, seminar question 1 and 2. The first question asks, what is meant by the sources of international law, and why Michel and Brett argue that identifying them is more complicated than in domestic law. The second question asks what the sources of public international law are, whether they are also the sources of private international law, and what happens if there is a conflict between sources. So here's the roadmap. I'll start with what we mean by sources, then I'll explain why they are more complex. Before looking at the main sources of public international law, comparing public and private international law, and finally explaining how conflicts are resolved with some case examples. When we talk about sources of international law, we mean the origins of the rules, where they come from, and how we identify them as legally binding. The International Court of Justice Statute Article 38 provides the classic framework. It lists three primary sources: treaties, customary international law, and general principles of law. Then there are subsidiary sources, which include judicial decisions and the writings of scholars. These don't create new laws, but they are persuasive and help with interpretation. So, when international lawyers talk about sources, they're talking about these recognized categories, not just physical documents. According to Michel and Brett, international law is more complicated than domestic law. In domestic system like Australia, the hierarchy is clear. The constitution sits at the top, then legislation passed by parliament and case law interpreting it. In contrast, there is no international parliament, no single Supreme Court, and no universal constitution for international law. Rules only bind states when they consent, either through treaties or long-standing custom. Another reason it's complex is that sources often overlap. For example, the UN Convention on the Law of the Sea codified many existing customary rules, but also introduced only new treaty obligations. This makes it harder to identify the exact source. According to Michel and Brett, international law is more complicated than domestic law. In domestic system like Australia, the hierarchy is clear. The constitution sits at the top, then legislation passed by parliament and case law interpreting it. In contrast, there is no international parliament, no single Supreme Court, and no universal constitution for international law. Rules only bind states when they consent, either through treaties or long-standing custom. Another reason it's complex is that sources often overlap. For example, the UN Convention on the Law of the Sea codified many existing customary rules, but also introduced only new treaty obligations. This makes it harder to identify the exact source. Now I will discuss about public versus private international law. It's also important to distinguish between public and private international law. Public international law governs relations between states and international organizations. Its sources are those in Article 38 of the ICJ statutes, treaties, customs, and general principles. For example, the Geneva Convention or the Paris Climate Agreement. Private international law, also called conflict of laws, is different. It deals with the disputes between private individuals or companies across borders. The sources here are usually domestic states and international conventions that have been adopted into national law. For example, the Hague Convention on International Child Abduction or Recognition of Foreign Contracts. So while both are international law, their sources are not exactly the same. What happens if different sources of public international law conflict? International law doesn't have a strict hierarchy, but there are guiding principles. First, lex posterior derogant priori, which means the later law prevails over the earlier one. And the second one is lex specialis derogant generali, which means the more specific rules prevails over the general one. But most importantly, just cogens norms, also called peremptory norms, sit at the very top. These are rules that no state can derogate from, like the prohibition of genocide, slavery, and torture. If a treaty conflicts with just cogence, that treaty is void under the Vienna Convention. Now let me give you three case examples to illustrate these principles. First, Nicaragua versus United States in 1986. The ICJ applied customary international law on the prohibition of force, even though the US had not consented to jurisdiction under certain treaties. This showed the custom is binding regardless of treaty participation. Second, Australia's reservation to the CEDAW Treaty. Australia limited its obligations by excluding women from combat duties. This shows how state consent is central to treaties, but also how reservations can weaken a treaty's impact. Third, the Furundžija case before the ICTY in 1998. The tribunal confirmed that the prohibition on torture is a just cogence norm. That means it binds all states, regardless of consent, and no treaty or practice can override it. To conclude, sources of international law are more complicated than domestic law because there is no single parliament or court creating rules. Instead, states create binding law through treaties, customary practice, and general principles. Public international law relies on Article 38 of the ICJ Statute, while private international law relies more on national system and conventions. While conflicts arise, rules of priority like lex specialis and lex posterior help, but peremptory norms like the ban on genocide or slavery are absolute. Understanding these sources is crucial for global lawyers because it explains not just what the law is, but why it's binding and legitimate. Thank you.